President Rick Swig will be the presiding officer tonight. He is joined by Vice President Ann Lazarus, Commissioner Eduardo Santacana, Commissioner Daryl Honda, and Commissioner Rachel Tanner. To my left is Deputy City Attorney Brad Rusty, who will provide the board with any needed legal advice. If you intend to testify at any of tonight's proceedings and wish to have the board give your testimony evidentiary weight, please stand if you are able, raise your right hand, and say, "I do," after you've been sworn in or affirmed. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. So item number 1 is general public comment. This is an opportunity for anyone who would like to speak on a matter within the board's jurisdiction, but that is not on tonight's calendar. Is there anyone here for general public comment?
Hi, my name is Paul McGavin. I'm here to talk to you about the case 18-1129, and that it was decided on August 9th of 2019. And that was a case that had some Indian tribes plus some significant interveners. And those interveners lived in Montgomery County, Maryland, and they also attracted the National Resources Defense Council. This case was about an FCC order that was trying to skirt National Environmental Policy Review, an NEPA Act, and they were caught. The judges didn't buy the argument. They didn't say that these things were small, or an 800,000 unit nationwide rollout was not impactful to the environment. And so they found it arbitrary and capricious, and they vacated that portion of the order to make it unlawful. Well, the wireless industry actually licenses its frequencies from the federal government. That makes every single small cell in San Francisco part of that federal undertaking. And we heard from the DC Circuit Court of Appeals that at this point, every application needs to have a completed environmental assessment or environmental impact statement in order to go forward. I've been listening to the tapes of this board for many, many weeks. You've been seeking some way to say, how do we stop this? This is exactly how you do it. You follow the DC Circuit Court of Appeals and you say, excuse me, until we have substantial written evidence in the public record that such a review has happened by the wireless industry and the FCC, then every application is now deemed incomplete. It takes a simple letter from your Department of Public Works to every applicant and their agent. You could do that tonight. You could actually inform the applicants and the agents here tonight. There's no need to hear any of these things because now everything must stop.
Thank you. Is there any other general public comment?
Good evening and welcome.
Hello, my name is Cheryl Lee Hogan.
Ms. Hogan, could you speak into the mic so
My
we can
name
hear
is
everything?
Cheryl Lee Hogan.
Thank you.
And I've
great.
come before you, and I'm coming to speak again about the microwave cell tower issues. I'd like to tell you some information that I have, and you have my documentation. The attorney for Verizon, Paul Albritton, stated that the microwave cell towers are allowed on fire stations in San Francisco. I called the firefighters union and was told that is not true. Paul Albritton said that Verizon would indemnify the city from possible harm from cell towers if there were lawsuits against the city by its citizens. You have documentation in my exhibits to the contrary. In fact, the SEC has mandated that the telecommunications companies alert their stockholders of potential risk, as their insurance companies will not even insure them. Paul Albritton introduces Daniel Rowe, Verizon's paid supposed expert, as a member of AIEE in a former meeting here. There is no AIEE. In 1963, AIEE combined with the Institute of Radio Engineers and established IEEE. I called New York IEEE. Daniel Rowe is not a member of IEEE, according to the Institute of Electrical and Electronic Engineers. IEEE representatives gladly spoke to me, as my father was executive vice president of IEEE and the recipient of the Frederick Phillips Gold Medal for his research in microwave technology. I'm going to also read a quote here from Richard Feynman, who got the Nobel Prize in Physics. It is our responsibility not to give the answer today as to what it is all about, to drive everybody down in that direction and to say this is a solution to it all, because we will be chained then to the limits of our present imagination.
Thank
Thank
you,
you,
Ms.
ma'am.
Hogan. Your time is up. Thank you.
Would you like a copy of Richard Feynman's quote?
No, thank you.
Is there any other general public comment? Okay, seeing none, we'll move on to item number 2. Commissioner comments and questions?
Commissioners? Madam Executive Director, could you please remind the Department of Health that they made a commitment to us several months ago about an update on the 2010 commentary on the dangers of, or not, of cell phone and wireless communications, and they made the commitment to have that report to us sometime, I believe, in early December. And would you please let them know that we are anxiously, and probably other members of the public, I'm going to make that big leap of faith, that we are all anxious to receive their report as they promised.
Thank you. Any other commissioner comments, questions? Is there any public comment on that item? Okay, please approach.
I did speak to Dr. Thomas Aragon on October 22nd and again yesterday by phone. And I have later, I can share with you, and I gave you an email today, it's in your packet that's on the dais, of all the people that we asked him to get in touch with. These are experts in the field. He's reached out to 2 of our list. There's actually 8 more. And so we're asking him to do the due diligence that is required before he revises this letter. And so we are expecting him that he may actually have to take another week in December to get it done. But we have very carefully gone through the December 10th memo, and we've given him contravening evidence to pretty much dispel most of that memo, so that now he has the duty to look at the science as it is now and to talk to the experts that we provided to then put his professional judgment, not his political issues, but his professional judgment on his medical determination. We expect that to happen in early December. Thank you.
Thank you. Is there any other public comment on that motion? Commissioner Santacana?
Aye.
Vice President Lazarus? Commissioner Tanner?
Aye.
President Swig?
Aye.
Okay, so that motion carries 5-0. Thank you. So we are now moving on to item number 6. This is appeal number 19-090, Roxanne Stachon versus San Francisco Public Works, Bureau of Street Use and Mapping. Subject properties, 2736 Broderick Street. Appealing the issuance on August 6, 2019 to Extenet Systems Incorporated of a wireless box permit. Construction of a personal wireless service facility in a zoning protected location. This is permit number 19 WR-00024, and we'll hear from the appellants first. Ms. Stachon? Thank you.
Good evening and welcome.
Hello. Good evening, President Swig and members of the board. Thank you for the opportunity to speak here tonight. My name is Roxanne Stachon. I'm a resident of 2730 Broderick Street. The basis of my appeal is that the city and its departments have not performed their responsibilities to ensure the permitting requirements of the proposed wireless facility at 2736 Broderick were met. Specifically, there is an error in the Department of Public Health determination, and the application did not comply with all of the Department of Public Health permit conditions. The public relies on its government to meet a minimum standard of care in carrying out its duties. A permit should not be approved when errors exist in the applications or conditions have not been met. Regarding the error in the public health determination memorandum dated February 22nd, 2019, the memorandum stated that the wireless relay unit will be oriented, the proposed unit will be oriented in the 98-degree direction pointing east along Broderick Street. 98 degrees is east from the true north. Broderick Street runs in the north-south direction. Along, according to Webster's dictionary, means in a line parallel with the length or direction of. So the antenna pointed at 98 degrees east cannot be directed in a line parallel with the length of Broderick Street. It's not possible. DPW's brief states, quote, she claimed that DPH erred by finding that one of the antennas would be pointed in an easterly direction along Broderick Street. I stand by that claim that the antenna cannot be pointed in an easterly direction along Broderick Street since the street runs north-south. As a resident who lives at a building that actually is 98 degrees from the pole, this error was not insignificant to me. Additionally, because I did some research about what these antennas were and read the city's FAQs on these antennas, it said typically they are directional in nature with a signal focused up and down the streets, not at residential buildings. This created obviously some confusion, and for these reasons, I did contact DPH and DPW and asked for clarification on this error. The error was never corrected, and information provided in response to these questions during the protest period did not correct this error. Instead, DPW and Exonet continue to state that there is no error, as they have done in their briefs for tonight. DPW included Exhibit M in their brief for tonight. Exhibit M is a memo from Mr. Duque of the Department of Public Health to the Department of Public Works. The memo was prepared last week. It states that Mr. Duque contacted the applicant about a possible error during his review on February 22nd. This is not accurate. The record shows that Mr. Duque contacted the applicant several months after, 3 months after, his review was complete and the department had already made its determination. I submitted that email from Mr. Duque as an exhibit. In the email, he asks Exonet, it looks as though the antenna will be directed east toward the building, so I wanted to know if this may be an error. Again, Mr. Duque is asking for clarification on what is being proposed after he has made his determination. Exhibit M further undermines the integrity of this process by trying to imply that this clarification was sought by Mr. Duque during his review when in fact it was not. In matters of public health, the citizens put their trust in the city to ensure that they know what is being proposed, the basics of how it will be cited, and ensure that the review and the determination is thorough and accurate. If this is not the case, the trust and credibility in the city is lost, and the trust and credibility of the process is lost. I do not believe approval should be made where there are errors. The second point I made was regarding the compliance with the permit conditions. Specifically, I outlined in my arguments that Exonet did not comply with the permit requirement, the accepted and stated permit requirement and condition that they have in place a procedure for taking RF power density levels in nearby dwellings when requested. Very early on in this process, I emailed Exonet inquiring about this specific permit requirement. I asked, quote, from my email, please provide details on the procedure that Exonet has in place to meet this permit requirement. I did this as a resident adjacent to the proposed installation, honestly just trying to understand what I could do, what were my rights, and how could I understand more about this facility. I never received a response to this request during the entire process until last week, November 14th, as part of their preparation for this hearing when Exonet emailed me. In their brief for tonight, they state, the appellant's statement that Exonet failed to explain the procedure is true. That should be the end of the story. This is a procedure that should have been, according to the permit conditions, in place as part of the permit approval, and apparently it was not. Again, after the approval of the permit, there's an attempt to correct shortcomings. Their brief today states, there's still plenty of time to ensure compliance with this condition of approval. Basically, we can still provide it even though it should have been done long ago. In conclusion, as a resident of this city, I would expect that these applications for wireless installations receive more careful examination than has occurred here. I'm sure it's relatively easy sitting at a desk in an office to approve paperwork, but for the residents who are adjacent to these facilities, it's not easy to understand why they receive such cursory review and streamlined approvals, even when there are documented errors and shortcomings in the applications. When mistakes are made, is it not too much to ask that the permit be denied so the process can be implemented correctly? In this day and age, getting the facts correct and ensuring integrity of the process is critical so that the public will have trust that there is a functioning system in place, especially for evaluating these important proposals. Thank you again for the opportunity.
Thank you.
We are
Thank
now
you.
moving on to public comment. Is there any public comment?
My name is Liz Buchanan. I'm speaking for someone. I don't see the name on here.
I'm sorry, I can't hear you.
I'm sorry, can you speak in the mic too?
Who am I speaking?
Can you speak?
Oh, no, Davidson, sorry. Hi, yes, sorry. I'm speaking for someone else. I attest and affirm that the following statements are true, accurate, and within my personal knowledge. I am reading a statement from Noah Davidson, who lives in Sacramento, California, which one of the first 5G test cities in the world, which is when 5G small cell deployment began in Sacramento in October 2018. In late December, Verizon installed a small cell antenna just 45 feet from my family's home at roughly the same height as our second story. The antenna has a 360 radiation pattern, and it is emitting very high levels of pulsed, data-modulated microwave radiation directly into my young niece's bedroom window. Within about a month of the antenna being installed, my nieces began experiencing health problems, including immune suppression manifested as persistent cold flu symptoms, in addition to sleep disturbances, headaches, and chronic fatigue. At the time, we were unaware of the negative health consequences of microwave radiation exposures and did not attribute the health problems to this antenna. My niece's symptoms persisted for 1 month before we began to consider the possibility that exposures from the antenna could be affecting them. We researched the topic thoroughly and found an abundance of peer-reviewed scientific studies with credible expert opinions suggesting that the health problems my nieces were experiencing could be a result of radiation exposure from Verizon's antennas. I'm sure that much of the data has been provided to you by local cell antenna opponents. My niece's health problems persisted for another month before we hired a local RF expert to come take readings inside our home. Is that it?
Thank you. Yes.
Thank you. A nice T-shirt, by the way.
Ma'am, can you please give a speaker
Next
card
speaker,
to Ms.
please.
Sullivan as well?
Next speaker, please.
Thank you.
This thing, I have one. Here. Sorry, thanks.
Welcome.
Hello, I'm Jess Lerner, and I'm here to address this issue. And I haven't been at previous meetings, so I apologize for any information I don't have. But in response to some of what you were just speaking about, I wanted to address directionality and also safety testing and FCC emission standards. So you may be aware that the FCC has not updated emission standards since 1996, when the Federal Telecommunications Act came out, when this technology did not exist. And directionality with regards to 5G goes in all directions at all times, including 3,000 feet, which is confirmed by the Verizon CEO. So you may already have this information. So right now we know that 5G is not safe, has never been tested for safety on or near humans, and will negatively impact our health. We know this industry is saying as long as there's no proven harm on their end, they may move forward for profit. Right now, all over the country, cities are writing and revising their ordinances, and you guys have the unique ability to kind of put the brakes on this and protect the public health and safety, as well as property values of those around you, and privacy, for that matter. So in terms of looking at what you can't do, you can look at what you can do. And there are a lot of tools that you can use. So I would urge you to review and look over the peer-reviewed literature and extensive medical and scientific information available, which are reliable, science-based, comprehensive, and conclusive articles about negative health impacts from wireless exposure. That includes Dr. Sharon Goldberg's testimony, studies done by the NIH, peer-reviewed articles from Physicians for Safe Technology, and so many more. There are vast data studies that prove harm, and we encourage you to investigate and review further. I think that means I have very little time left.
30 seconds.
Okay, we need to remember that the FCC is truly a captured agency that will do whatever it can to hide authentic data from the public, say there is no risk, and accelerate their own profit. I can send you some of this research if you do not have access to it, and I thank you for taking this very seriously and protecting the public. Thank you.
Thank you. Next speaker, please. Also, the last speaker, did you give a speaker card to Ms. Sullivan? Thanks. If you could come back. Please go ahead, ma'am.
And welcome.
Good evening. My name is Rachel Gaunt. Nice to be here. Thank you. Now, we wouldn't be here sitting around if this technology that we're talking about had a color or a smell or something, right? It's invisible. It's an invisible toxin. We know that that it's a carcinogen. And if you marry the fact that most people that you talk to are unaware of the dangers of 5G, 4 and 5G, they love their technology, but actually if they knew the science, they'd think differently. So if you marry the fact that most people don't know about this yet, and you marry that with the fact that we have a 1996 federal act that made it illegal to complain about health effects, and you marry that also with the fact that the allowable levels are 20 years out of date, and proven that even the allowable levels are too high. You have a sort of a recipe for almost like a public health crisis. And I want to refer you to a town called Bern in Switzerland that a couple of weeks ago had a protest of over 3,000 people in just one city come out and protest. And that's because they have rolled out 5G technology already in Switzerland. These are the people who are the guinea pigs of this technology, and they're complaining and they're protesting because they're getting sick. Real live illness symptoms. So this is real. We're talking about forced radiation on an unsuspecting public, and that just makes no sense at all, particularly if in your office, and the oath of office is to protect the health and well-being of the people of San Francisco. Thank you very much.
Thank you. Next
Thank
speaker.
you. If you could give a speaker card to Ms. Sullivan, please. Thanks.
And welcome.
Helen Greco, I did put a speaker card in. I'm reading into the public record testimony relevant to this appeal. I attest and affirm the following statements are true, accurate, and within my personal knowledge. The following is testimony that Edward B. Myers wrote for November 19th, 19 hearing in Montgomery County, Maryland. I'm an attorney, and I was an intervener in the D.C. Circuit case 18-1129, along with the Natural Resources Defense Council. The Federal Communications Commission issued a rulemaking order on March 9th, 2018 to expedite the development of densified 4G, 5G, and other advanced wireless facilities, so-called small cell by the FCC. The FCC's order exempted all of these 4 5G facilities from 2 kinds of previously required review: historic preservation review under the National Historic Preservation Act, NHPA, and environmental review under the National Environmental Policy Act, NEPA. That's significant. On August 9th, 2019, the U.S. Court of Appeals for the District of Columbia Circuit vacated the FCC's rulemaking order. The legal effect of vacating the FCC's rulemaking necessarily means that the prior rule was reinstated, and any actions taken on the basis of the vacated rule had to be reconsidered under the terms of the prior rule. The prior rule required that the FCC need to apply an NEPA to the construction of 5G facilities. Consequently, it is not lawful for any such facilities to be constructed without prior NEPA federal review. Any city or county needs to comply with this, so this whole process is moot because you haven't done that process. Thank you.
Thank you.
Thank you.
Next speaker.
Just one speaker. My daughter wanted to stand next to me. She's been very helpful through the whole process.
And very patient. Thank you for being patient, sweetie.
All right, great. I'm going to finish the little testimony that was from Noah Davidson, because the conclusions are very important for San Francisco. And excuse my voice, I have a little bit of a cold, okay? Although small cell antennas use less power than macro sites, exposure from small cells can be much higher in residences and other areas where people are because the antennas are much closer to those areas. They essentially are putting the same macro tower antennas and radios literally in San Francisco 6 to 12 feet. RF engineer hired by Sonoma and Napa, Lee Offleback, made it known in the public record, it's the same equipment. So that is the problem. You have 3 variables that you have to measure, and you have to jigger to figure out what you're going to do to get out of the box. You got vertical offset, how tall is the antenna off the ground? Horizontal offset, how far away is it from people? And then you got the maximum power output level. That is the one that is completely under your control. And all you need to do is provide enough maximum power output for the things that the FCC has preemption for. That's only voice calls. The FCC on October 1st had upheld in the DC Circuit, they no longer regulate the internet. They stepped back, they pulled their teeth. They have no preemption for data frequencies. Only voice, and it only needs less than 0.04 watts from the shroud of the antenna. That will do it. That will get you coverage half a mile down the street. That'll get you 5 bars on a cell phone, and that will not endanger your people. The problem is the one at 2620 Laguna, 7,000 watts of affected radiated power. 7,000. I measured today. I went around. Next public comment, I'll tell you what I found.
Thank you.
Thank you.
Next speaker.
Good evening, board members. Ingrid Evans. I wanted to say that appellants to the next appeal, 18 WR 0185, join in the arguments and briefing by Ms. Stachin, as specifically Evans, Klein, and Patel. I would also like to add that this case that came up earlier, the United Kitawa versus FCC case, which was recently decided by the DC Circuit, is very instrumental here, and I think is going to change the game on this, and I think it's something that the board should pay attention to. It is going to be required that these small cell towers and these wireless permits be required to do an environmental impact, and that is something that should be done. And I would request that all of these permits be delayed until DPH has gotten back to you on the health effects and an environmental impact study has been done. Thank you.
Thank you.
Thank you. Next speaker, please.
Hello, board members and President Swig. My name is Michael Levesque. I am electrically sensitive. It has been a tremendous struggle these last few years, maintaining health and relationships. I see this also around me by others affected similarly, but not the same. Each individual is different. Thank you for being here and enduring these hours of appeals, many hours, and especially thank you for asking the Department of Health to update the 2010 position on wireless facilities in the city. It's 1982. You answer your phone, never thinking twice about its safety. It's the touch-tone telephone. In the 1990s, the pager becomes fashionable, with over 60 million people throughout the world using pages. In an instant, they become obsolete and the cell phone becomes popular. Then the smartphone emerges, and by 2017, the U.S. has over 300 million cellular phone users being exposed endlessly to high levels of EMFs rarely experienced before this age of communication. Now, 2019, over 6 billion people use cell phones in the world. Cellular antennas in California in 2019 number 2,023,382 and climbing. The wealth-creating aspects emerges as $20 to $30 trillion in the next few years. Wealth has become the major influence and motivator for this technology. Unfortunately, wealth can create greed that ignores wisdom and comprehension, that ignores judgment and heresy, that interrupts the reverberation, the very essence of life's pulsation within the universe and eternity. Just as the Board of Appeals stands behind Article 25 of the 1996 Telecommunications Act, it can just as easily stand behind a precautionary principle resolution and have faith in the recent court decisions and recent briefs to win their day in the court for all of us.
Thank you.
Thank you.
Next speaker, please.
Hello, my name is Paige Hudson. I'm happy to be here tonight. I don't have prepared comments, so I'm just going to speak to you from my heart as a very concerned citizen who has been very steeped in this process of trying to educate our communities here in California and across the nation about the dangers of small cell, close-range cellular towers. I often ponder why we're still having this conversation when there are over 2,000 peer-reviewed studies that show us the dramatic impact that even lower levels at 3 and 4G are having on our population, ranging from headaches and discomfort of sleeping to the most severe, which is, of course, glioblastoma and brain tumors that are very aggressive. As a cancer survivor myself, my son is a cancer survivor, and my very best friend right now is battling level 4 glioblastoma, which in no uncertain terms, her doctors have advised her that it was a result of wireless routers and cell phone towers in her neighborhood. I'm asking that question about why we're still having this conversation, because with this overwhelming evidence that even at lower levels, our population is at risk for serious modifications in their DNA. And the answer is because of a very outdated, unjust Telecommunications Act of 1996 that says that we as a population cannot resist the rollout of these high-level small cell towers based on health concerns. I can't imagine a reason more important than our health to do so. And the burden of proof should not fall on us to say it's dangerous. when the telecommunications companies were before the Senate hearings and were asked how much money they had spent in determining the safety of these higher level radiation small cell towers. The answer was not one single dollar. So we are going to be used as guinea pigs as they roll this out without your help to protect us.
Thank you. Is there any other public comment? Okay, we're going to move on to rebuttal. Ms. Stachon?
2 minutes or 3 minutes?
Pardon?
2 minutes or 3 minutes?
3 minutes.
3 minutes, okay. Well, here I thought I was just going to be all by myself today. Little did I know. So thank you, everyone who made comments. I think you've totally freaked me out. But just so you know how I came here, I actually started as just a person who had this thing posted on the pole right outside my house. And I wanted to find more information, honestly, wanted to find more information. I use my phone. I like it. I've heard these things are controversial. I wanted to understand what was being proposed. There were some questions about the directional nature and what was shared. This maybe on the overhead.
Please. Overhead.
Thank you.
Okay. The only thing I could see was this arrow pointing at my house. That's how this started, honestly. And actually, the second antenna, the more powerful pull-top omnidirectional antenna, I wasn't even worried about at first because I could get no information on that. I contacted Exonet the same time I asked about the RF measuring, and I asked for all the information. Should I even file a protest? I have no idea. I didn't get the information until after the protest date, so I did file a protest. The reason I wasn't freaked out was because of this. And it said that this is the planning department FAQs that were published on small cells. And it says that they're rounded, but they're directional. And they primarily are focused up and down the streets and not directly into the residents behind the pole. So I'm like, okay, that's cool. That sounds pretty good to me. I think I'm going to be able to live with this thing 12 feet outside my bedroom window. And it wasn't until after the protests were filed that I saw the memo that described the omnidirectional antenna on top, which honestly I did have to go to Webster's and make sure I knew what that meant. And then the second antenna was pointed east and up and down Broderick. So now I'm super confused. And at that point, I contacted DPW, who directed me to DPH, who then apparently emailed Exonet to also get clarification.
Could you leave that on the overhead, please? I'm sorry. Sorry
Yes.
to interrupt your time. Thank you. Sorry, I didn't mean to interrupt.
No, that's okay. So that's kind of how I ended up here. This is a little schematic for you. When I did start to get a little freaked out about the omnidirectional pole, this is our building, this is the pole, this is the bedroom, and this is my home office. So I was like, whoa, this is, weird. I don't know about this. But I get it. It's FCC, and we're not allowed to really talk about it. What I do want to say, though, at the end of the day, I'm really talking about a process here. Obviously, these are super controversial, and the I's should be dotted and the T's should be crossed and the information should be provided. And I don't think they should be approved if that information isn't correct and accurate to the residents. So thank you.
Thank you. And your brief was very well done for a first-timer.
Thank you.
Thank you. Commissioners, this matter submitted.
Commissioners?
I have to say I consider this matter somewhat moot.
I agree. As my vice president has indicated prior, with the recent legislation from the San Francisco Board of Supervisors, this would no longer be heard in front of this particular forum. Permit's not required. It's administrative through the PUC at this point. And just as a side note, I mean, we've heard quite a few cases on this. We are very concerned. We've asked public health to step up. We understand this is just, I mean, for me personally, I feel that this is just like the tobacco industry in the 50s. And as one person has stated, I too am a stage 4 cancer survivor. My son is also a cancer survivor, and my daughter had kidney failure. So I get it more than most people. So at this point, was the permit issued properly? I believe it was. And again, going forward, this will not be in front of our body. You want to make a motion?
Just for housekeeping purposes, and because it was brought up, and this is de novo, I'd like to ask our counsel, please, why or why not the precautionary principle that was mentioned is valid or invalid today's hearing. You've answered it in the past.
I don't think it was brought up with respect to this particular case, but that is a...
Yeah, in public comment it was.
It does not put any enforceable duty on the board to take any particular action in respect to this, and that the board's review of this permit is whether it complies with Article 25 of the Public Works Code.
Yeah, thank you. Motion?
Move to deny the appeal on the basis that the permit was properly issued and that the permit is no longer required.
Okay, we have a motion from Vice President Lazarus to deny the appeal and uphold the permit on the basis that it was properly issued and on the basis that a permit is no longer required for this type of poll. On that motion, Commissioner Santacana?
Aye.
Commissioner Honda?
Aye.
Commissioner Tanner?
Aye.
President Swig?
Aye.
Okay, so that motion carries 5-0, and the
Okay,
appeal is
welcome
denied.
back
To the regular meeting of the Board of Appeals. Today is November 20th, 2019. We are now on items 7A, 7B, and 7C. Appeal numbers 19-071, 072, and 073. Ingrid Evans, Giselle Cordestani, and Kayleen Patel versus San Francisco Public Works, Bureau of Street Use and Mapping. Subject property, 2735 Green Street. Appealing the issuance on June 14, 2019 to GTE MobileNet of California, LP, of a personal wireless service facility site permit. Construction of a personal wireless service facility in a zoning protected location. This is permit number 18WR-0185, and we will hear from Ms. Evans first. You have 7 minutes.
Good evening, Ingrid Evans. For the record, all appellants, Evans, Klein, Patel, and Cordestani, would like to join in the briefs and arguments of the others for Appeal 18WR0185. I'd first like to start with the Public Works Ordinance 190-19 that you talked about earlier making a lot of these appeals moot. And I would argue in this situation it is not moot. And the reason why it is not moot is because permit 18WR0185 was applied for, issued, and appealed all before July 1st, 2019. And that is before the ordinance was enacted, which was August 9th, 2019, okay? Ordinances are not applied retroactively unless the ordinance law expressly says so. This ordinance does not allow for it to be retroactive, and therefore it is not applicable. It does not moot this appeal. That is a California Supreme Court decision that says that these laws cannot be retroactive. Myers versus Philip Morris Company, 28 Cal 4th 828, 2002 case. Next issue is notice. Notice is a procedural due process requirement that is required under the California Constitution and California state law. The California Supreme Court requires procedural due process to be strictly complied with, and notice is a shall requirement under 1512 of the San Francisco Public Works Code. Here, the notice must go to the residents within 150 feet, to the Cow Hollow Association, and to be posted conspicuously. I would argue that the brief addresses all the issues of notice. However, the Cow Hollow Association notice, I want to take on a little more detailed here, because what we requested when we wrote to Verizon, we did not get any type of mailing list from them as to what addresses they actually sent the notice to. And we learned in the opposition for the first time from DPW and from Verizon that the mailing list included old addresses for the Cow Hollow Association. It did not include the current president, Lori Brooke. It did not include the Cow Hollow Association P.O. Box, which is on the website. They are required to strictly adhere to that requirement of notice. And if they don't, this permit is procedurally flawed and cannot be granted. Next issue is I would like to submit the evidence of the Cow Hollow Association website that shows the proper address that should have been served. In this situation, in administrative hearings like this, there is no procedure for a reply brief, but the California Supreme Court in Superior Court allows for reply briefs, and it is required if there are new issues that are raised. Both the issues of 190-19 and the issue of notice, which was different than the notice packet that we were provided when I requested notice from the subcontractor of Verizon, are new issues that came up first on opposition. So I'm entitled to reply of those issues. And I'd ask the board to consider my supplemental evidence as a late submission. I have received approval from the other appellants, not from DPW though, and not from Verizon. So I would ask the court to consider some papers that I have that will help substantiate the record for the notice issue.
You can go unnoticed by verbally. And it's by the rules of this body. It's too late to submit anything further, but you can present as part of your brief.
Okay. The next issue is the notice of posting. The posting was misleading. There were two pictures of the same posting on the block. I believe that does not comply with 1512, and it's not procedurally, they have not complied with the rule. Lastly, the issues of health and specifically the issues of public and private nuisance. The briefs of Verizon claim that public and private nuisance are preempted and the health issues are preempted. Specifically in California, common law is not preempted, and public and private nuisance are common law remedies that are not preempted and can be brought. So there are FCC regulations that preempt the cities and counties from doing certain things regarding health and safety, and we know that's been a common issue, but I don't believe the issue of public and private nuisance by a private citizen has been raised, and I believe that is a proper remedy that can be brought to stop these permits from being issued. Lastly, the case that I raised earlier requiring a NEPA and an environmental impact, the United Kiowa versus FCC case, which was decided by the DC Circuit, I think mandates in this situation that the board hold off on issuing any more of these permits or allowing these permits to go forward until there's been a comprehensive environmental impact and until there has been a study, as President Swig has requested from DPH. We've been waiting for that for a while. I have not seen anything come out, nor has the board, and we would request that all of these permits be deferred and continued until that has been done to allow us to have proper findings on the health and safety of these issues. Thank you.
Thank you.
Thank you. We'll now hear from the next appellant.
Good evening.
Good evening. My name is Ashley Brakefield of Farrell, LeBron, and Martel, and I represent Giselle Cordestani, who's here with me tonight on her appeal.
Can you hold one moment? We have a disclosure from President Swig regarding, if you can stop the time.
Farrell, LeBron, Martel has represented me on unrelated issues and prior, and their presence here tonight will not impact my view in any way, shape, or form on this item.
Thank you. My apologies.
Thank you.
No problem. Thanks, President Swig.
Please start the time.
At the outset, I want to recognize that this board, and it's already been said tonight, everyone stole my thunder before I got up here, has heard hundreds of these kinds of appeals before. And we understand that you've heard many, if not all, of the same arguments before. I've watched hearings in preparation for today, and I know that despite the number of times you've all faced these issues, you've given thoughtful consideration to them, and that's appreciated. I think the number of these appeals you've seen speaks to something important, and that's that community members continue to be concerned about these facilities. And they feel uninformed, left without recourse to have their concerns addressed, and they look for whatever avenue they can find that allows them to alert the city about problems with the process and issues with potential health impacts. That avenue leads directly to this board. And I know you have also expressed some concern. I know on the June 19th hearing, the board engaged in lengthy discussion about this. At the June 26th hearing, you asked officially for DPH to update its 2010 memo, and I know that was spoken about earlier tonight, and they have not yet done it. I say all of this now before getting into the merits because I think it's important to place my client's appeal and the other appeals you have and will see on the same issues into context. We recognize that your hands are tied when it comes to the overall regulatory process concerning wireless service facilities. Community members, including my client, are concerned about the lack of transparency and communication between city agencies, the FCC, and the public, whether it's regarding updates to health impact studies or changes to the permitting process. They feel left in the dark, and they're only made aware of changes to the process when they find out an installation is happening right outside their bedroom window. These are real concerns, and I think that context is important. On to the merits. As stated in our brief, our appeal has 4 main arguments, though we also join in the arguments of the other appellants here on this matter tonight. The project is in violation of the DPW condition that no new poles be erected or placed in underground districts. Number 2, that the project is in violation of the condition that the personal wireless service facility installation not obstruct views from any adjacent residential window. Number 3, that planning incorrectly determined that the application meets the compatibility standard. And number 4, that DPH incorrectly determined that the application complies with a public health compliance standard. On the first issue, that this should be considered a new pole, I was amused at Verizon's brief characterizing the argument as half-hearted. It reminded me of my dark days in litigation before switching over to the transactional side of things. But I would argue that their response doesn't actually address the issue. DPW placed a condition on this project, condition number 2, that no new poles be erected or placed in underground districts. This is a new pole. It's a pole that's not currently there. It's in fact taller than and not a replica of the existing pole. My client didn't write the language, DPW did. Contrary to DPW's assertion that the basis of this argument is not Public Works Section 1500. As stated in our brief, DPW's own notices for this project, which went out to members of the public for the express purpose of providing members with information relevant to their concerns, stated that no new poles be erected or placed in underground districts. The public is entitled to take such information on face value and rely on it, and that goes to the heart of what I spoke about earlier, that the public is frustrated by what they perceive to be a backdoor, non-transparent process that is out of their control and impacts them greatly. At the very least, they should be able to rely on the plain language of the notices provided. On the second issue regarding obstruction of residential views, we again run into an issue wherein the conditions of approval in the documents sent out to the public don't provide critical information for the public. There is a clear condition that the new wireless facility would not obstruct views from residential windows. Nothing says substantially obstruct views. Nothing cites to other DPW orders. That's all the language says, and that's all the public has to rely on when they're reviewing these notices that they suddenly get. In particular, a copy or reference of DPW Order 184504 is nowhere in the final determination. DPW cites to a single email with a 2-line completely redacted, so it's unclear who actually got the email, that does refer to these orders. But that's not the same as the planning department staff explaining in their approvals how they concluded, that a particular project will meet or not meet the various conditions of approval. On the third issue, both Verizon and DPW dismissed the argument that the project is on a disfavored site based on conclusory statements. Both claim that the wireless telecommunications services guidance cited by my client applies only to permits on private property, yet nowhere in the guidance does it say that. Neither DPW or Verizon cite any evidence in support of their statement. Verizon and DPW also ignore the city planning data for wireless permit project cited in the Cordestani brief on page 5, footnote 3. As noted, there are other streets deemed excellent for wireless siting, and the planning department approval failed to discuss alternative locations that are preferred, indicating that none were considered. Finally, on the issue of public health, which is what we've heard the most about tonight, I circle back to my comments at the beginning. As this board has discussed in several hearings, DPH has been forced to comply with health standards put forth by the FCC based on an incredibly outdated 1996 study. Although several organizations have reviewed the effect of emissions from transmitters, no formal updates to the study itself have been made. And given preemption issues, DPH is not able to fully address potential health and safety issues. Further, FCC has not provided the public with any studies or reports explaining the long-term health impacts associated with human exposure and radio frequency energy. In a particularly surprising argument, DPW charges my client with presenting evidence that RF emissions from the proposed wireless facility would exceed FCC limits. I don't believe the responsibility for scientific testing and data interpretation falls on residents of the city. I believe it falls on city agencies. And while it is true that post-installation and operation, Verizon is required to test RF emissions, the board can imagine that residents of this city, my client included, are wary of trusting a process that they feel has not been transparent. This is particularly so when DPW, in just the prior breath, essentially told a resident to do their work for them. As I noted at the outset, you hear so many of these appeals because there are a lot of concerns. And while the track record for these appeals is not good, concerned residents of this city feel it is important to continue to bring these issues to this board and to the attention of whatever city body will hear them, in the hope that these issues can be corrected, the process can be more transparent, and improperly approved determinations like this one can be overturned. Thank you.
Thank you.
Thank you. We will now hear from the next appellant, Ms. Patel.
Hi there. My name is Kayleen Patel. I live at 2735 Green Street, which is the address of the pole.
Overhead, please.
So it's right outside of my children's bedroom window. And of course, when you find out that this is going to go up, you start doing research as much as you can. And you're disturbed to learn that, yes, it is very outdated research and that it refers to things being below the horizontal beam where this is directly in line with it. And it feels very discouraging to know that there's no further health studies and that there don't seem to be any forthcoming. Whatever health studies have been done are not long-term, do not include the current technology. But you've heard all this before. The thing that I don't understand is why are there so many? Why are there so many permits for these antennas? If you look at a map, it's like measles. Roxanne lives right around the corner from me. There's another one going down a block away at Lion and Green. I don't understand why this is being pushed on us. These are service providers, and we don't want this service. It's not a case of NIMBY because this isn't a cell tower. These are antennas that only benefit the block that it's on. But nobody on the block wants it. The cell reception is fine. In fact, it's a lot better now that the Russians are gone. So
That's right, you live on that block.
Yeah, they were scrambling. But it's not necessary, and especially in this magnitude. And so the only thing that made sense to me after I thought about it is that this is a land grab. The FCC has determined that you can't say no to them putting it on a pole. So, of course, Verizon is going to be an idiot if they don't try to stake their flag on it, because then someone else will. And then they'll be blocked out. So it makes sense because there's been no discipline imposed on how many antennas there can be put up in the city. It's just a free-for-all. And so, of course, they're going to ask for as many permits as they can get, even though it's not needed. There's a cell tower on the hill above Lion Street that gives us great reception. So I would beg that there be some discipline imposed on the necessity for these towers. I know that your hands are tied in a lot of ways, but I think that it's important for the municipalities to have control over what their constituents want. And for health concerns, for property values, for just lack of any benefit, these should be revisited, and hopefully there's a way that San Francisco can reassert its authority to decide what it wants based on what its citizens want. And I think that what you're hearing is the citizens do not want this, they do not need it, and that their concerns are much greater than any benefit that will come from having these. So I beg that whatever discretion that you have, please use it towards an act of reason, imposing discipline, and finding some way to mandate more studies. If you can please use your position and power to find ways to do this and hopefully allow San Francisco to have more control over its regulations, I would appreciate that. Thank you.
Thank you.
Thank you. We'll now hear from the permit holder.
God, we haven't seen you in a bit, Mr. Albritton, Councilor Albritton.
Thank you. Paul Albritton, outside counsel
Welcome.
for Verizon Wireless. President Swig and Vice President Lazarus, we really do our best to avoid bringing appealed facilities up before you, and there are many of these applications that are going forward, and I know it seems like you've seen many of them. I think I was counting, we've had maybe 2 or 3 dozen come before you, and we've been doing this for about 10 years and have hundreds of sites throughout San Francisco. So there is careful attention to that. And with respect to the history, I was renewing the 6th 2-year utility condition permit for Verizon Wireless for small cells in San Francisco. Our first utility condition permit in 2008 includes the indemnity and insurance provisions that are required under the code that's a separate permit for all of our facilities in addition to these individual permits. And you probably remember that this whole process went before the Board of Supervisors, and that they looked at the design and they eliminated some designs and allowed this design. And that we have to go through the San Francisco Public Utility Commission to get a master lease for these facilities, and then an individual site license, which we've done for this facility as well. The design itself, you all remember Omar Masri. Forgive me if I use the old name of the IEEE. Fortunately, I've not called you guys the Board of Permit Appeals for a long time.
Yep.
But we went through, with Omar Masri, a careful, long 2-year process coming up with this design, which was ultimately copied by AT&T. We took the design before the Historic Commission in order to, for those facilities that would be in front of historic locations, in order to come up with a process that has been carefully worked through with the Department of Public Works, the Planning Department in terms of their level of review, Department of Public Health. You have some of the most rigorous review of any community that I know of with respect to these applications, an 11-point checklist and information that's reviewed by a public health officer. The rigor and transparency in San Francisco is superb, and San Francisco has that reputation, and it deserves to have that kind of process. As a result, we do have over 400 small cells in San Francisco now that are operating, providing an extremely vital service. You probably heard of the recent test of the earthquake warning system, which will send a text message to all cell phones within moments before an earthquake, and that's the kind of robust capacity that Verizon Wireless and other carriers have to reach every member of the community with a moment's notice of an earthquake. And the reason that our facilities are close into neighborhoods, they're extremely low wattage. This particular facility, the lowest wattage we ever get to, 122 watts, is designed to provide that kind of capacity and service in times of crisis and generally for the types of services that people demand. I want to quickly run through some of the issues that were raised. There was a notice issue that was raised in the briefing this evening. Those arguments were cut back, I think, substantially. Because Ms. Evans is not in the notice radius, the initial information that Verizon provided to her did not provide all of the address notices. It is subsequently in the briefs that were submitted by both DPW and Verizon Wireless, and I think that led to some of the confusion. With respect to the Cow Hollow Neighborhood Association, Section 1512 of Article 25 requires that we provide notice to the neighborhood associations at the address identified by the planning department. So the process is we go to a contractor who then goes to the planning department webpage, downloads the association addresses that are to be provided, and that's the address that we use. This particular facility was noticed both in September 2018 and also in March of 2019. On the list, there are 3 representatives from the Cow Hollow Association. On the planning department webpage for the site, it says that the neighborhood associations are responsible for ensuring that the address that they provide to the planning department is up to date. And that's the address we used for the Cow Hollow Neighborhood Association. We also notified the Marina Cow Hollow Neighborhood Association. So there were 2 neighborhood associations that were identified. With respect to the photographs of the pole that appears in the September photographs, the consultant had 2 of the same pole and didn't line up the photographs. As the DPW brief reveals, all 3 poles are photographed in the March notice that went out, and the notices were there. Evidently, the photograph was mixed up. That is the issue of notice. There was an issue of SIMs. It wasn't raised this evening that we hadn't pointed the arrow at the radios. And I just have to say that, as DPW said in their brief, the radios are very apparent from the SIMs. You don't have to have an arrow next to them. But I think it speaks to the design that we've used. These radios are only 10 inches wide, 5 inches deep. And unless you look closely, you don't realize that they're there. And that's the whole concept behind this facility. The antenna only extends the height of the pole by 2 feet. And then with these narrow radios right next to it. I guess I'll jump to that issue quickly. I think it's very clear, and DPW in their brief cites the appropriate code sections, that a replacement pole is not a new pole. And I don't think that's, in an underground district, that's at all questionable. That if DPW is unable or ever able to replace a broken light standard after it had been hit by a car because it was a new pole instead of a replacement pole, we'd be missing a lot of light standards in San Francisco. There was also the claim that we didn't meet the compatibility standard or that somehow this blocked views. I've discussed this with you many times. The planning department did a very careful review. They have to determine whether, and they do conclude that this does not significantly detract from the defining characteristics of the residential neighborhood. I think that's perfectly clear. You have made that determinations many times, as has the planning department, and that's based on that very careful design where we have no exposed cables. We have very, very tight conditions in terms of the angle of the conduit that enters into the pole and the kinds of what the design must look like. With respect to views, you know that the code does not protect private views. There is a condition of approval that we agree to that says we won't obstruct lighter view, and then the definition of it under Order 184504, which is that in order to obstruct a view, it has to be within 8 feet of a window and 20 inches in diameter. In this case, I believe we're 33 feet away from the closest window, and there just isn't any way that we could be obstructing views. And we also believe that the planning department accurately confirmed that there's no significant impairment of any aesthetic attributes of any historic resource in the area. We don't think there's, with this type of facility, this light standard type of facility, any concern in that regard. With respect to RF, there's been a substantial discussion about the health effects. This particular facility, I have to say, lowest wattage, 122 watts. On the ground, it will be 0.054% of the 0.056% of the FCC standard. That's about 2,000 times below the FCC standard. At the window you were looking at, which is 33 feet away from the pole, it's less than 0.5%, also 2,000 times below the window. In this case, the antennas are directional, 80 degrees and 260 degrees, looking up and down the street, and so there's no antenna that's actually facing that building. I guess I should add also in response to some of the comments that I mentioned Raj Mathur of the Hammett and Edison company that does these reports was on the subcommittee for the IEEE, which just concluded their review. They review the standard every 7 years, and they concluded it earlier this year and confirmed that the standard should remain at the level that it's at with respect to emissions. The FCC has had since 2013 a review process regarding the standard, and they announced earlier this summer that they were going to reaffirm the standard. And that's because the physics has not changed. The frequencies have not changed. They've been around for a long time, and the standards are adequate and are what they should be, and they are constantly reviewed. There was also the discussion of nuisance. The appellant in that case cites the civil code section that she's referring to, that this would be a nuisance, and it's particularly referring, as she says, a nuisance that causes injury to health. She's clearly referring to the RF emissions and somehow the RF emissions constituting a nuisance, and because we're within the FCC standards, this is not an issue that is within your purview. It would be a civil matter, as she pointed out, and as well as the DPW brief points out, and an issue if there is a nuisance that she would have that issue with Verizon Wireless. But there isn't any because of the health effects. The one case that's cited regarding aesthetic impacts from nuisance is only if the aesthetic impact is substantial and unreasonable. Again, we're 33 feet away from a window, and the case that is cited is dealing with a macro T-Mobile site next to a home, and your own order, your own language suggests that there's no way that this could be considered to be some kind of aesthetic nuisance. Finally, there was a question by Appellant Korstani regarding whether we had chosen the right pole. We have an extensive alternatives analysis. We can bring it up and show it to you if you wish. We have facilities on Broderick. We have facilities on Vallejo. We have facilities on Union. And so this is the location that we need to be within those facilities in order to create our network. The poles are carefully selected to actually have the maximum distance from homes, balconies, and so forth, and also provide the network with the minimum number of towers or minimum number of facilities. And that's what we have done in this case. I don't want to take.
You have 10 minutes and 30 seconds.
Oh my God!
Only 10 minutes and 40 seconds.
I was going to refer to some of this on rebuttal. The Quinoa case that you're hearing about, the NEPA case in the D.C. court, was an Indian tribe. The case basically says that for wireless small cell facilities on Indian land, that there is no categorical exemption, and for historic sites that are under National Historic Preservation, there is in addition to the CEQA review that these facilities have already gone through CEQA exemption and so forth, Verizon has to comply with a national NEPA review. And that NEPA review under FCC, there's a programmatic agreement between FCC and EPA that allows certain facilities to be categorically exempt. Any facility that's 33 feet, 10 meters in the air is categorically exempt. And there are other categorical exemptions. What that case did is it took the categorical exemption that the FCC had granted for small cell facilities and said, no, you can't do that on tribal lands, and no, you can't do it in these national historic situations. That review has nothing to do with a CEQA EIR, totally different. The review that's done by FCC in terms of their environmental review, and it just puts you through a different environmental review where you have to go through further environmental review with the FCC, but it has nothing to do with an EIR. All of these facilities are categorically are exempt, and this facility certainly would be because of its low wattage. I think somebody's having a coughing fit. I believe that I think I've covered all of the appeal issues, but I would be happy to answer any questions that you have. I'd like to say that I personally continue to believe that cell phones save lives tremendously. I've been going through a number of the North Bay evacuations and so forth, and the cell phone is the primary resource for NIXL and any number of alerts that people rely on. And the wireless companies, particularly Verizon Wireless, prides itself on 80% penetration of generators so that we can keep our facilities operating during the PSPS and everything else. So and with all of the concerns you hear about Verizon Wireless or its facilities, I hope that you bear in mind, I think every one of us has a situation where a cell phone came into an emergency situation that potentially saved their lives or saved them from injury or other potential harm or discomfort. With that, I'll sit down or answer any questions you have, but I'll be back on rebuttal. Thank you.
I have two questions, if I may.
Sure.
4G
We'll just work
or-
our way down the line.
4G or 5G?
Short answer or long answer? This is a 4G facility. It could not be converted to 5G without going through DPH review,
And
as we've
you
already heard.
as well have obtained the license under the new legislation for this site?
We already have the license.
Right.
Which raises the question of...
I know. I just wanted
Yeah, but we do have a
confirm.
license, yes.
Thank you.
From PUC, we go through rigorous analysis with SFPUC.
So,
Mr. Santacana, do you have anything? Okay, go ahead. All right.
This is actually the most time that you've ever used in all the time that
I'm
you've
sorry.
been before us.
I apologize.
It's okay. The attorneys were very good in their argument, so I get that. But and as usual, your brief was always well prepared and in answering the appellant's question. Your briefs are actually very, very concise, and they do answer it. You mentioned in time of crisis, earthquake. So these are small towers. So in that type of situation, as in you mentioned the fire, a lot of cell towers were not working. I mean, there's no backup battery for this. So during a major crisis, are these towers actually going to be physically working?
Well, there are a lot of crises that occur when the power remains up. We recently had a shooting in Orinda, for example, where
No, but you mentioned specifically earthquakes.
Yeah.
So in earthquakes, as in '89 when I was here, we lost power for a couple days in a good portion of the city. So without power, does this tower still particularly work?
This particular individual small cells, we are not putting battery backup on these. We could put battery backup on these, but due to aesthetics, we are not. But there are many emergencies where the power does not cut out. And I also was here in 1989, and I have to tell you that my cell phone continued working. And
not mine.
It was
Not
mostly,
mine.
well, maybe you should consider Verizon Wireless.
And so, like I said, when you mention earthquake and time of crisis, when we really need them, as in the fires, I mean, a lot of people's phones were not working, especially these small towers that don't have a large backup battery. And to answer a member of the public's question, why there's so many is because it's a small tower without a huge infrastructure with lots of wattage, correct?
The reason, I think you're asking me
A couple at one time.
two quick
sorry.
questions,
Yeah.
I promise. And that
Sorry.
is, and Verizon had a very good record. We only lost 97%. We had 97% of our facilities operating in the 2017 North Bay fires, and they were all back up within a week. We had, in the last instance, we had one tower down. We had statewide 188 running on generator. And so it was, Verizon has remained very robust. The small cell network, as I mentioned, is very important for providing capacity. 72% of homes now, 72% of homes do not have a wireline phone. So there isn't another way to reach people in a time of emergency. And in that earthquake warning I'm talking about is before the earthquake. Yeah. So your power is going to be on before the earthquake. I heard interesting discussions today with City Attorney Herrera about PG&E and maintaining power in the city, and I think that is something that definitely the city should work on.
Okay, and then last question: how many cities or counties in California ban this type of technology, if any?
Ban this type of technology?
Yeah.
There are a couple of cities. The North Bay seems to be a hotbed that have attempted to pass 5G moratoriums, or if you review their codes like Mill Valley or Petaluma, you will find that buried in the code is that the technology is not allowed unless it would violate state or federal law. And the state and federal law allow first for telephone corporations to place wireless facilities in the right-of-way, subject to the cities and counties' rights, recently confirmed in the T-Mobile versus San Francisco case. And then the federal law, of course, doesn't allow any community to have any regulation that would prohibit the provision of service. And so all of those, any ban, would fall in the face of those codes.
So that no city and county in California can ban 4G or 5G technology?
That's correct. That's absolutely correct. I've heard, I think it was the mayor of Danville who said, we can adopt that kind of feel-good ordinance like Mill Valley, but that's all it is. It's a feel-good ordinance. When push comes to shove and we need to put in facilities and the city has that kind of ban, then we have the right to provide that service. And that's because the state has said that it's a matter of statewide concern, and the nation has said it's an interest of national concern that people have the ability to use their cell phones here, New York, Las Vegas.
Thank you, Mr. Albritton.
Yeah.
You are a wealth of information. It's terrible to hear, but you are a wealth of information. Thank you.
Maybe I've been doing this too long. Thank you very much. Always appreciate being in front of this body.
This may be appropriate in anticipation of what I think is going to come in public comment. So you may want to answer this in rebuttal, but I'll give you a shot to answer it now.
Thank you.
So I've been here for a couple of dozen of your appearances, so you have witnessed stacks and stacks and stacks of documentation which has been presented to this body, which has now been forwarded to the DPH for further review on how these technologies are killing people, or certainly causing grievous harm to people. When you stand up, you confuse me, or maybe the public, at least me. I'm easy to confuse. I'm not so smart. But IEEE is electrical engineers, and it's a lobbying organization as well as a think tank. The FCC, that's communications. Federal department, but what I never hear is where's the American Medical Association, where's the National Institute of Health, where's something that has to do with health. Yet we come with these reams of paper from your opposition about all the people that are being harmed. Can you tell me how many are there any lawsuits, whether they be class action, whether they be individual lawsuits, such as the ones that we referenced, the tobacco industry in the earlier case, or there was some reference. Are there any outstanding lawsuits in this country that are on behalf of individuals who are claiming that they are being harmed from cell towers, from cellular related use, or any telecommunications use whatsoever, please?
I am sure there are. I have not ever had to defend one in the state of California, and I am not aware of any successful case. Now, I may be wrong, but I'm not aware of any successful case that has confirmed or any kind of direct link or liability between cell phones and cancer. You can look. You're asking for information. There is information on the NIH webpage. There's information on the American Cancer Society webpage. There's the information on the World Health Organization webpage, as well as the FCC webpage, that all go through the compendium of studies that have occurred and show that there's no proven direct link between cell phone towers and cancer. And I have to say, in the reverse, there are many cases of where cell phones have saved lives. I'm sure you've heard of many of them. We all remember the couple
That wasn't
yeah.
the question I was looking
Yeah.
for.
And I guess in the short, if you have, given your prior comments, and I respect your desire for an answer that's comprehensible, I would direct you to the Scientific American article written last month, October 23rd, regarding this entire issue, and the I can't remember the title of it, but something like the myth of the health risk of wireless facilities. October 23, Scientific American.
I would invite you, I don't know if it's, I have to look at council, but you may want to send a note to all of us with that article for our interest in education for future cases, so I don't have to ask you dumb questions like this. Or maybe it's a smart question, I don't know.
Well, I'll confess that we don't try and address that issue with you. There's plenty of educational information out there, and we're not trying to argue left or right on that particular issue. We feel very strongly that the federal law is constantly reviewed and is the right course for the country.
Yeah,
and
you can
the state.
see, however, the deep concern of this public, where a statute that was, I don't know if I had a cell phone in 1989,
1996.
Or not, but when you see a statute written in 1996 and the FCC hasn't bothered to update it yet, as a cell phone addict, I know that I've had a few upgrades since 1996, and things have changed since 1996. So you can understand the concern of the public that maybe things are a little bit behind the time with regard to study, and also you can understand, I hope, that that even the city of San Francisco, in its wisdom, has now a 10-year-old study which is almost 10 years old, and a few things have happened in 2010. So. Since 2010. So that's why I asked the question, with all these reams of stuff that people bring into us, have there been any lawsuits? Have there been any firm evidence of individuals who and we heard one tonight. I don't know whether it's real or not, because that's on, for study tonight. We don't have any detail on it. But are people in fact dying from cell tower being installed in front of their homes? And are there any lawsuits related to that?
Answered that.
And I don't want to take your time. I can speak at length, and if you'd like to have some kind of forum on how to best address that, I'd be happy to participate, or with DPH. The ADA was written in 1990, and it's still applicable today. And the point is that the 1996 Act created certain policies and procedures, and those the FCC has just gone through, opened up in 2013 a review of the standard, and is ready to close it. Announced earlier this year that it was going to close that review and to keep the standard the same. And at the same time, there have been thousands of studies with respect to this effect. It's ongoing, and compendiums of studies and peer reviews of studies, and the smoking gun isn't there. People relate it to asbestos and tobacco, but we didn't. These rules are reviewed by the EPA, the Food and Drug Administration, and a lot of other agencies that we didn't have back in those days, and thoroughly reviewed. We're happy to have DPH review this issue carefully and thoroughly.
Thank you.
Thank you for asking your questions, and thank you for letting me take so much time.
Thank you.
Thank you. We will now hear from the department. You have 21 minutes.
And if you choose to use it, you won't be allowed in the building next time.
Good afternoon, President, Vice President, and members of the board. I'm Leo Palacios, representing Public Works. We believe that this permit was issued in compliance with the permitting procedure defined in Public Works Code, Article 25, for a personal wireless service facility at the time of issuance. Article 25 requires Public Works to refer wireless applications to the Department of Public Health and the Planning Department. Both departments determined that this application complies with Article 25. Public Works subsequently issued a tentative approval, and the applicant mailed and posted notice of this approval. Public Works held a public hearing to consider protests to the tentative approval. Following the hearing, the Director of Public Works approved the permit, and notice of this determination was distributed to the public. The Planning Department is in attendance and can speak more regarding planning's review. If the board has questions, the Health Department is not in attendance, but is available to take in questions and respond through email.
You have 20 minutes left.
Any questions? Are you done?
I am done.
Any questions, commissioners? Okay.
And the officer in the back, we put the chair there just for you guys, so just in case.
Thank you. We will now hear from the Planning Department.
How many minutes does Scott have?
21 minutes.
Turn the mic off.
I intend to use them all. Can I tell you a story? Scott Sanchez, Planning Department. So similar to the last case, I believe that the subject application was properly reviewed by the Planning Department. Also similar to the last case, it's both a planning and a zoning protected location. Planning protected location because it's within the same eligible Cow Hollow, First Bay Tradition Historic District. Unlike the last one, it is not on a street with any designated views. It's a non-designated street view street. And it's also within an RH1 zoning district, which makes it zoning protected location. Then some issues were raised about the neighborhood notification, and that material is generally, the responsibility of the Planning Department. And I just looked now at the mailing list, and Cow Hollow Association has not updated their contact information. That said, in my experience, we've never had an issue communicating with the Cow Hollow Association. They're quite engaged and responsive to the notices that we mail out. So the names that are on there are names that I recognize for quite some time. But if they do choose to, at any time, they can update their mailing contact information. I do notice that the contact information that's listed on their website is different than what they have given to us, but that is their choice. Often neighborhood associations have specific chairs or specific subgroups that deal with land use, and they want the thousands of notices that we send out every year, not everybody else. With that, I'm available for questions. Again, given that this is on a pole owned by the PUC, it's my understanding that under the rules which are currently in place, this would not require a permit. Thank you.
Thank you. Use more time. Quick question, Mr. Sanchez. Do you have Verizon or AT&T? Yeah.
I wish I had Verizon during the
Okay.
power outages, because it sounds like it was working better.
Okay, thank you. We are now moving on to public comment. How many people are here for public comment? Okay, if you could line up against the wall so we could keep the process moving, I'd appreciate it. And everyone has 2 minutes each.
And first speaker, please come up. First speaker, thank you.
Hi, I'm Liz Buchanan. I attest and affirm that the following statements are true, accurate, and within my personal knowledge. In an October 22nd, 2019 email to Thomas J. Aragon, Health Officer, San Francisco Department of Public Health. Start. One great solution is to set a maximum effective radiated power limit from the face of the antenna shroud at 40 milliwatts by adding the following to Article 25. Quote, for a wireless telecommunications facility that is installed in the public rights-of-way or attached to any building or antennas installed at heights lower than 100 feet off the ground, the applicant must install only antennas, radios, and other supporting equipment that have no chance of exceeding a total of 40 milliwatts of effective radiated power from all of the equipment operating at or connected to the specific WTF, wireless telecommunications facility. A cap of 40 milliwatts of ERP provides 4 main benefits. 1, it provides coverage for telecommunications service for about 1/2 mile from the source antenna. 2, does not effectively prohibit telecommunications service. 3, adds the speed limits, seatbelts, and airbags like regulations that San Franciscans need to protect the quiet enjoyment of San Francisco streets, which is part of SF's aesthetics. 4, it is compliant with FCC guidelines. I have expressed no matter of mere concern, but solely matters of substance, fact, and law. I guess that's it.
Thank you.
Thank you. Next
Ms.
speaker.
Sullivan, her speaker card is right there on the ledge. Okay, next speaker, please.
Hello again, Rachel Gaunt. I want to just address a couple of what seem to me like alternative facts from the previous speaker. There is, let's take the Cow Hollow area where we're talking about the Green Street and Broderick Street. There is already plenty of cell phone coverage, 5 bars, the woman said. We don't need the additional small cells to add more cell phone coverage. We have it. Secondly, in a disaster like a fire and earthquake, the small cells go down more easily. You want actually the bigger ones that stay on and last longer. So I disagree with his representation of those particular facts. If I sent you a Scientific American article the month after the article he's talking about, it would have a very comprehensive rebuttal of everything in that article by Professor Joel Moskowitz from the Berkeley Family School of Medicine. So I'd be happy to send you that article as well. I just feel sorry for the people who are up here appealing it. Here, it's like a lottery. Put these things outside their bedroom window, as opposed to, maybe yours, for example, right? And you've got grandchildren staying over, or children, and or maybe an aging mother who needs some extra support. The whole process is just completely unfair. Why are these people scrambling, spending money on lawyers, trying to barricade their house like Faraday cages because something arbitrarily got put outside their bedroom window with absolutely no recourse? I could no more go and outside your house, for example, and put a very, very strong light or very, very noise 24/7, and that would get taken down immediately. You would not tolerate that. Why are we tolerating it? Something that, in our view, is 10 times more powerful and more destructive to the human body. Thank you.
Thank you.
Thank you. Next speaker, please.
Hello again, Paige Hudson. Like most things that we know in our current life, if you follow the money trail, you'll get lots of answers. So it was equally painful, as my colleague Rachel mentioned, to hear the gentleman from Verizon speaking about the need for this in emergency situations. You heard from neighbors who said that they don't need or want this. So why is this technology being rammed down our throats to the detriment of our families? It's because Comcast has really monopolized the market for residential, and AT&T, Verizon, and other carriers are none too happy. It is a marketing ploy to be packaged in a way that says that we need this for emergency services and for better communication, which is simply not the case. You still have access to your cell phone. We're not against technology. We're not against cell phones. I think they have great value, obviously, for all of us. That's not the point. The point is we are being conned into believing that we need this small cell towers next to our homes. Distance is your friend when it comes to radiation exposure. And to have these powerful cell towers right next to our children's bedrooms, it's bordering on child endangerment. We all can agree that children's skulls are much thinner, and the FCC regulations are based on a 230 or 250-pound man, adult male. This is not something we want near our children's bedrooms. Lastly, I know you are all very aware of the precautionary principle, but I'm a little perplexed as to why this is not being invoked here. As a reminder for all of us, the precautionary principle, the principle that the induction of a new product or process whose ultimate effects are disputed or unknown should be resisted. There's not a single dollar, as I mentioned earlier, being spent proving that 5G is safe. So why are we allowing it to be rolled out?
Thank you.
Thank you.
Will you please give a speaker card to Ms. Sullivan?
Yes,
Thanks.
Hi, I'm Helen Greco. Thanks for having me here. I moved to the city when I was 22 years old. I lived here for the next 17 years. Currently, I live in Petaluma. I'm one of the co-founders of My Street, My Choice, where we did actually ban putting these 5G and 4G towers in residential areas successfully. So I beg to differ with Mr. Verizon. What I want to put on the record here today is there was a California law, AB 57, that bans these towers by any firefighters in the state. You can't put it near a fire station. So that means that they're perfectly safe. So the firefighters won, but we didn't get. These companies can't get in liability insurance because they don't want to insure them because they're not comfortable being able to do that for the liability. So why isn't that being mentioned by Mr. Verizon? So this is what I want to draw your attention to today. I attest and affirm that the following statements are true, accurate, and within my personal knowledge. This is from an October 24th, 2019 email to Thomas Argonne, the health officer of the San Francisco Department of Health. Dear Mr. Argonne, at a Sonoma Planning Commission meeting, September 12th, 2019, Lee Afflerbach, a consultant from CTC, RF exposures from a close proximity microwave radiation antenna. So there's statements in here. I don't want to take too much time, but you've got the video. Please refer to the comments in minute 3, 10 seconds, 24, and the comments in minute 3, 13 seconds, 22. But the bottom line is this. I'll summarize it for you. And it basically says that that's the proximity that matters. I can't get this work, more technology fun. The point is, it's about the power, and it's about the proximity, and how that exponentially raises the power. You know, this is not my first rodeo. Here we are with corporations and citizens. Haven't we been down this road before? What do we have to do? We just have to wait for more brain cancer and things like that, and then we'll go, oops, we're sorry.
Thank you, ma'am. Your time's up.
Thank you.
I test and affirm, that the following statements are true, accurate, and within my personal knowledge. You are getting a slick sales job by the wireless industry. I hope you can actually figure out the real answer here, okay? These people are telling you things that are not true. And I'm here to tell you that we have already put into the public record. You have here the actual case, the Ketawa case. It was not just tribes. It was also interveners that were fully recognized. And those people live in neighborhoods, Montgomery County, Maryland. And that ruling applies to the entire United States. That is upheld by the judges, by the DC Court of Appeals. The wireless industry is being painted into a corner. They don't like it. They're desperate. They're going to tell you whatever story they want to tell you. Read the case. That's all you need to do. It's in your public record. Now, what I'm saying to you is that you're also being misinformed about all these things about, oh, guess what? If you're compliant with an FCC guideline, that implies safety. It does not. You can't get binders like this. You can't get people getting injured after 2 weeks of exposure in Sacramento where they have to move the kids out of the front room into a back room and shield the house and spend thousands of dollars just to protect themselves. And get Verizon in a room last Thursday with 5 representatives to figure out how are they going to fix the problem quietly. Okay? This is a real problem. People are really getting sick across the United States right now. And all you have to do is look at the actual information. It's all in your public record. You have it now. And you have every reason to strike down, support all of these appeals tonight, waiting for the NEPA environmental assessment. It is higher than CEQA. Come on, folks. Take the ring. Do something for your people. You got your out. You don't have to wait for the Department of Health. You got what you need from the D.C. Circuit Court of Appeals, and yet you rubber stamp them, rubber stamp them, rubber stamp them. What are you doing?
Thank you. Next speaker, please.
Hello, I'm Jess Lerner, and I just want to introduce myself to you because I didn't get to last time and say a few things. But before I do that, I do want to say that based on the knowledge that I have that I can share with all of you, the data that I have, and the tremendous amount of information that many of us have, Mr. Albritton was misleading you tremendously. And there's a ton of data I really encourage you to look at and read to be fully informed about the truth. So again, so I'm here right now because I've been working on this issue, partly because I'm also electrically sensitive. I discovered this when I was in grad school at Brown for environmental science, and I have been for years now aware that I get headaches and can't sleep around wireless. That's why I live pretty far away. I don't live here in San Francisco. I came from an hour away. I probably would be living somewhere in a city right now if I could, but I physically can't. I can tell you, and anyone who's been through health concerns, like you were speaking about earlier, that what is more important than our health? Nothing. You can't really do anything without your health. So I want to ask, how can health and safety and the precautionary principle not come first? So I agree with pausing until the NEPA review is done. I agree with listening to local control, which is what a lot of people in the North Bay have been talking about. I really hope you guys can catch up and get educated on all of this. I know it's an issue you don't know a lot about, and the reason you don't know a lot about it is the fact that the industry has been so successful at strategically silencing and suppressing all of the data and the information that you don't want to know and that you don't need to know for them to get cash in their pockets. It isn't about emergency connectedness. This won't help you in emergency. That's not what 5G is about. It's about cash. So when the public says we don't want it here, I urge you and ask you to listen to what the public says rather than forcing radiation on the public that's saying no. Thank you.
Thank you. Will you please provide a speaker card? Thank you. Is there any other public comment? Okay, so we'll move on to rebuttal. Ms. Evans? You have 3 minutes.
Thank you. Giving proper notice is incumbent upon the permit holder, and that is the responsibility of Verizon here. Verizon did not meet that obligation of notice, and it's, like I said earlier, strict compliance. They are required, and the statute says shall give notice to the Cow Hollow Association. They did not do it properly. The statute actually says any neighborhood association identified by the planning department for any neighborhood within 300 feet of the proposed personal wireless service facility. It does not say the planning department has to keep an updated list. Mr. Albright attempted to put the onus on the planning department. It says that the planning department has to identify the associations, and it does. It keeps a general list of all of the associations in San Francisco, but it is not incumbent upon them to keep an updated list. They did not meet their requirement. There was no effort. There was no diligence by them. They could have easily gone to the Cow Hollow website. It's a public website, as Mr. Sanchez just did, or I did. It clearly says who the president is. It's Lori Brook, and it has a P.O. box on that website. They did not do that. For that reason alone, this permit needs to be denied. And the other reason, as I went into a lot of detail earlier, is 190.-19 is not effective in this situation. It is not retroactive. It is not appropriate here. Thank you.
Thank you. We'll now hear from Ms. Patel. I'm sorry, Ms. Cordestani.
Hi, I'm Giselle Cordestani. You heard from my lawyer before. And the reason why I felt like I had to bring a lawyer with me was the last time I came to the public hearing, I found it very difficult to speak. I found it very intimidating to talk to all of you. And I must say, I'm an MBA. I have had a professional career for a very long time, but it's extremely scary and hard to come forward. But I feel very passionately about a wireless antenna outside my home that is 20 feet away from my bedroom, the bedroom of my children. I have a 1-year-old, a 4-year-old, and a 7-year-old. And the 2735, I live at 2740 Green Street. It is literally the closest thing possible to my children's bedroom window. And when I came to appeal, I appealed because I can now, the street has no above-ground utilities at all. They're going to introduce for the first time an above-ground utility on a street that is historic. These buildings are all classified. For me to even remodel is excruciatingly painful to get applications to remodel my home. Every single home on that street is completely classified as one of a historic site, a historic neighborhood. So why introduce an above-ground utility is beyond me. The second is that I am fearful of the health concerns, but I was told I can't bring those up because the federal laws overrule, which seems crazy because this is actually the only place where I can come and talk to you to try to stop this. But when you voted on the last appeal that's on Broderick Street is half a block away from my house. There's a 4G antenna going up with Sprint half a block away and one right in front of my house. also 4G, which I have been told up until today that that was 5G. So I don't know what is true now. And on top of it, we were told in the last hearing that the direction does matter and it's going to run up and down Green Street and not affect you and not be directly to your house. But Broderick isn't perpendicular to my street. And so which antenna is going to go which way? Are theirs going to go up and down and ours go this way? And aren't we just in the center of all of that because it's 4 houses away? Doesn't make sense to me. And so if you're just going to sit here and say that, well, it's moot because the laws changed before we were able to cancel this, then I would ask you to consider returning our $300 that we all had to pay to come here to talk to you, and also my legal fees, because I feel like the process is so scary that I can't come and talk to you directly, that I need to hire a lawyer because it's so complicated. And for you to ask health questions of a legal representative of Verizon, I think is not correct. Ask a professional.
Thank you.
Thank you. We will now hear from Ms. Patel. You have 3 minutes.
Hi. I just wanted to speak to a few things that the Verizon representative said. Obviously, we're not in favor of getting rid of cellular, but the reason that we all have these stories of having saved someone's life or having a cellular phone help us is because it already works. We don't need 5G. We have coverage. It's fine. We don't need this new technology. But even if we do decide to go that route, we need the testing done on the new technology. And what I would say is that you're not a scientist. I'm not a scientist. Nobody in this room can listen to this and determine what is the correct answer as far as if this is causing a health problem. But we can determine that more studies need to be done and that the constituents who would benefit from this technology are choosing to forego it because out of precaution. So if the people that would be benefiting from it say, no, thank you, then why is it being forced upon them? And your job in the city is to reflect your constituents, is to speak for them, to hear their voice, and to represent them as far as you can legally. And I know that in many ways your hands are tied, but I also hope that you can find a way to do so and to be able to get authority back to San Franciscans for our own codes and ordinances, similar to how San Francisco adopted gay marriage and medical marijuana early on. I do not believe that putting in the ordinance would be a feel-good option. Obviously, it might be overruled later on, but it would send a message, and it would apply pressure for more studies to be done, and it would lead the way as we have done before. And I feel that it's really important. I hope that you can take time to take all of this under consideration. I know that you see so many of these. I know that this is just one more, but I can also tell that you're very compassionate and empathetic. You all have your own stories and are dealing with things that you're concerned about in this regard. And I just hope that you could take all of this under submission instead of deciding tonight. Maybe take time to talk as a quorum and find out if there is a legal way that you can push forward in representing your constituents. Thank you so much.
Thank you.
Thank you. Mr. Albritton, anything further?
Oh, that sounded like maybe I shouldn't talk very much. I won't. Paul Albritton, outside counsel for Verizon. I just want to touch on a couple of quick things. And I mentioned why small cells, and then I'll say what I've always said to you, and you know that you can look up in your phone what the emissions are from your phone by going to general and legal and look and see that the phone, when it's adjacent to your head, is very close to 100% of the FCC standard. And when it has to talk to a cell phone tower that's a mile away, it can ramp up in power 1,000 times. And that the small cell network actually provides these very low wattage facilities so that the cell phone doesn't have to work as hard in order to talk to the tower. And that's not the reason for the small cell network, but it certainly does provide these facilities closer to the end user. I also want to point out that there is post-installation testing, and I hope everyone here who is nearby one of these facilities, you can either call or email the Department of Public Works. That's how it works. That's the network, the system, and we will make sure that your home, wherever you want, we will test that location at the time that we do the post-installation testing, and that should be something that I hope is somewhat reassuring to some of the people here this evening. You do have a professional who reviews these issues, and that's your Department of Public Health. You have health professionals, one of the few communities in the state, maybe the only, as a health professional, reviewing these analyses. And that's, you're to be commended for that. And I think I noted that several years ago, DPH went out and got their own meter. So they can go out and measure the cumulative impact from any of these facilities anywhere around the town. And when we do a post-installation testing, it is cumulative. It's taking into account AT&T, Sprint, and everybody else. Very quickly on AB 57, I think I've told you before, it does not prohibit facilities on fire stations. AB 57, I have to say I wrote the first drafts of that. It deems an application approved if a community doesn't act on it within the FCC shot clock periods. That deemed approval, the automatic approval without community review, doesn't apply to fire stations, and that's because of the importance of ingress and egress from fire stations, and also that the fire departments frequently aren't the reviewing entity for those kinds of facilities, so a deemed approval may affect them. That's all it is, an exemption from deemed approval, but there are plenty of facilities on fire facilities. With respect to Sonoma and Mr. Lee Afflerbach, he's with CTC Communications. He represents municipalities on RF issues, and I commend him to you. He's very qualified, and in Sonoma and our presentations there, all of our facilities comply, and that's what he said in his statements. I wanted to, first, you commended our briefs, and I wanted to congratulate my colleague, Melanie Sengupta, who actually drafts those briefs, and I get to review them, but she reminded me that that NEPA does apply nationwide, so all of our facilities go through NEPA, and I didn't mean to express anything with respect to that case to suggest that we don't have NEPA review. And our facilities are either categorically exempt or go through the FCC NEPA process. We've been doing that since 1984. So it's a standard part of the process, and as I mentioned, through this agreement that's been reached between the EPA, the FCC, and the carriers. I don't want to take up any more of your time. I was going to respond to some of the other questions, unless you want me to respond to some of the other inquiries. I guess with respect to Cow Hollow, again, the code says 1512. It's neighborhood associations identified by the planning department. And I think you heard from the planning department that the Cow Hollow Neighborhood Association does receive notice on a regular basis. With that, I will sit down unless you have any questions, and thank you so much for your time.
Is it your responsibility? It would seem that under the notice item, it would be Verizon's responsibility versus the planning department's responsibility to notice the Cow Hollow Association, given that it's not exactly a secret. You're familiar. Your firm is a very knowledgeable, seasoned firm. Can I finish, please?
Yes, please. I'm sorry.
Your firm is a knowledgeable, seasoned firm. They know about neighborhood associations and the detail of that an address may be obsolete on a website. Should not be it would seem a barrier or a burden to provide proper notice to a very well-known and high-profile neighborhood association. Do you agree?
I would respond by saying that, as Mr. Sanchez pointed out, in working with neighborhood associations, I know that most of them do have committees. They have a land use committee. So it's not the chair or the president of the association that you contact, but the people who are responsible for land use, and the committee makes a report to the general association with respect. So there were 3 Cow Hollow Association names. I understand from Mr. Sanchez this evening, those continue to be the 3 names registered with the planning department. So as far as I know, we, in addition to complying with Article 25, have complied with the wishes of the Cow Hollow Neighborhood Association, the Marina Cow Hollow Neighborhood Association, and other neighborhood associations and business associations that are listed in our addressees. So we rely on that information, and they are obligated to do their own self-reporting. But I think it would be a mistake for us if we had sent a notice to the president but not noticed their identified individuals on a committee, then we would be remiss. But we are following the letter of the law and in a practice that we've continued to carry. And we do work with neighborhood
Do
associations.
you honestly believe you're under oath that you did the most diligent job in noticing the Cow Hollow Association, regardless of whether the address was correct or not on the website, given that they are a known association and given your level of sophistication in noticing associations?
I think the question is, did we comply with the noticing requirements? And did obviously I don't review every notice that goes out. There's a contractor, Modus, that then contracts out to an approved noticing agency for San Francisco that professionally does this and signs an affidavit and provides you with that affidavit that they have complied with all of the requirements under the code. And I think, again, I would be remiss to try and second guess, personally, I would be remiss to try and second guess that process, which has been well institutionalized in San Francisco. And one of the reasons that San Francisco has such a careful and rigorous process is because it's been institutionalized over the last 11 years.
But is it not ultimately Verizon's responsibility to ensure that a neighborhood, the appropriate neighborhood association is notified, whether it be the committee, whether it be the president, just as being responsive and responsible to the neighbors in that neighborhood? Or the
I think
citizens
I would agree with you that we need to not follow the letter and the spirit of the law. And as far as I know, we have done that in this case.
Thank you.
Thank you.
Thank you. We'll now hear from the department. Mr. Palacios. Okay. Mr. Sanchez, anything further? Okay.
Wow, we just saved 18 minutes.
Commissioners, this matter is submitted.
Okay, commissioners.
I don't mind starting. I want to speak to the appellants and some of the members of the public who've come out to speak tonight. Thank you for your time, and sincerely, this city doesn't work if our citizens don't work, so thank you for all the effort that you've put into participating, and I know it's been a long night, but I really appreciate all the work that you've put into this evening. One thing about our body, and I've only served on it, just had my 1-year anniversary just recently.
Happy anniversary.
Thank you, of being on this board, and our role is really to assess and determine primarily whether or not permits have been properly issued in accordance with the rules that have been laid out for how the permits should be issued. So in this case, Article 25 governs how these permits are issued, and we look at rigorously, as you guys have presented evidence of perhaps that wasn't followed with regard to noticing or other items that are in that that article, which is what locally governs us. That's the question that's before us. And so when it can be confusing, why aren't we considering health? Why aren't we considering these other things? Why are we not doing things? That's the role that our body plays. The Board of Supervisors this year passed legislation, which then becomes law, which then becomes the other way to look at and determine our permits properly issued, that changes the way that cell towers and wireless facilities are permitted in the city. And so when we say the issue is moot, as Vice President Lazarus said for the last case, it means that they already actually have a permit to put a facility at this location under that other process. So even if we were to find that this permit was not properly issued, a separate permit under a different process has already been issued for a facility at this location. And so we wouldn't want you to be under the impression that upholding your appeal would lead to the elimination of this facility that's near to your home that you are appealing. So I encourage you to, if you do want to keep active, continue to think about contacting your member of the Board of Supervisors, other folks who are organizing to try to change the overall policies which are governing this, which then this board is the subject to really thinking through, was this permit properly issued? So I hope you know that we are listening, we are hearing every word, we really care deeply about the things that are before you, but we also have a duty that we need to uphold in terms of what are the bounds and what are the role that we have to play here. So with that said, I would submit to my fellow commissioners, I have not found evidence or heard evidence that would persuade me that this permit has not been properly issued.
I agree. I believe that was a wonderful comment. That was wonderful. I mean, we do care a lot. I personally had a doctor said that you should get your affairs in order. I've personally seen both my children go through life-threatening illnesses when no one 5 generations before me has ever had these illnesses. So I constantly say profit over humanity. I believe in this particular case that is so. We've had hundreds of cases. She's been on for a year. My vice president and I have been on here for over 7 years. We've heard hundreds of cases with many, many really bright attorneys and appellants and public that have come before us giving personal statements, legal argument, and at the end of the day, even after this legislation, we're still here and we're not able to break that code. We are extremely, extremely sympathetic. As I mentioned in the last hearing, you know, we all live in San Francisco. Most of us have families. Most of us have a cell tower on our block. I do. And so extremely sympathetic. And I hope in the future that, in the very near future, that we'll get a handle on this 4G and 5G. But as my fellow commissioner eloquently put, what's before us, we don't, at this point, there's nothing that says that we should overturn this particular permit.
Anybody else? So I'd just like to say that had I had the chance, I would have been, before a motion was offered, I would have offered another motion, which I probably would have got slapped down for, or we would have ended up in court. I would love to continue this item until we had my motion would have been to continue the item until we had a clear view from the Department of Health.
It only takes 3 votes to pass that motion.
And so that would be my motion.
I would support that.
My city attorney might not like that very much, but that would be my alternative motion, that we continue this case until, because we have, my point on this is nobody knows, and the health department has been dragging their feet, really. I mean, we've requested over and over again. So, you know, the call of the chair would be, let's continue this until the Department of Health responds to us, to our request, and comes to to you, the citizens of San Francisco. They do their job. We're not scientists, and we get resolution on this, and then I don't know whether there's closure, but at least there's something further. But that would have been my motion.
You can make that motion. I just said that I didn't see anything, but I would be willing to support that motion if you make it.
I just want to say I don't understand the practical impact of that motion, considering that they have a license and they're going to go forward.
You know,
So that's just my comment.
I absolutely agree with you 100%, and I'll continue. I will continue to make my motion. If I get shot down, I get shot down. But that's
make your motion, Mr. President.
My motion is to continue this item until the Department of Health comes forth with their requested update of the 2010 opinion on the subject of the health and welfare of cell towers and other telecommunications devices.
Okay, so we have a motion from President Swig to continue this matter until the Department of Public Health updates their memo and responds to the board's request regarding the health effects and wireless networks. On that motion, Commissioner Santacana?
No.
Vice President Lazarus?
No.
Commissioner Honda?
Aye.
Commissioner Tanner?
Aye.
Okay, so that motion carries with 3 votes, and so the matter is continued.
Thank you.